Good afternoon, and thank you all for joining us here, both in the room and those watching the stream at home or in their office. We're going to get started here with our speakers in a few seconds. I just wanted to let everyone watching and listening on the stream that if you have any questions, you can submit them to me, Alex Frank, at afrank@hastingsgroupmedia.com. Again, that's afrank@hastingsgroupmedia.com. We have 5 speakers from the newly formed Investor-Advocacy Coalition here today. We have representatives from PIABA, the Public Investor Advocates Bar Association, Better Markets, NACA, the National Association of Consumer Advocates, Public Citizen, and CFA, the Consumer Federation of America. Our first speaker today will be Joe Pfeiffer, the president of PIABA. You will then next hear from Christine Hines, the legislative director at the National Association of Consumer Advocates, followed by Brady Williams, legal counsel at Better Markets. Then from Martha Perez Penamonte, civil justice and consumer rights counsel at Public Citizen. And then last but not least, Micah Hotman, director of investor protection at the Consumer Federation of America. But let's first begin with Joe. Joe, take it away.
Good afternoon, everyone. My name is Joe Pfeiffer, and I'm an attorney based in New Orleans, the founding partner of the law firm Pfeiffer, Wolf, Carr, Kane, Conway, and Wise, and the president of PIABA. Over the course of my career, I've represented thousands of investors, and collectively, the members of PIABA have represented over 100,000 investors. To begin today, I want to thank everyone for joining us, especially my colleague sitting up here next to me, who will speak to the policy implications of this issue. But what I'm here to talk about is what I see when investors are forced into an arbitration process that's unfair, a process that too often leaves retirees ripped off by unscrupulous RIAs and then priced out of justice by forced arbitration clauses inserted by folks who I call fake fiduciaries. First, I'll talk a little bit about Rita Bertadelli. Rita was a registered nurse who saved little by little over the course of a few decades, enough to create a modest nest egg for herself. She put her trust in a registered investment advisor, someone who claimed they were a fiduciary, someone Rita thought could help her take care of her nest egg, look out for her, and make sound investment decisions on her behalf. Unfortunately, Rita, like many Americans, suffered an unexpected health problem. She had 2 life-altering brain aneurysms that left her incapacitated. And the advisor that she trusts, the advisor that held herself out as a fiduciary, that Rita trusted to manage her hard-earned money, instead lost over $250,000. And that was pretty much everything that Rita was able to save over the course of her lifetime. It was gone. Poof. Rita's representative looked into recovering her losses. We looked at this, and we learned it would cost $200,000 up front to pay the forced arbitration fees to attempt to hold her advisor accountable. That forced arbitration clause, hidden away in an obscure provision of Rita's contract, essentially priced Rita out of justice, like many other Americans with the same clause in their contracts. To say that a little differently, even if Rita went all the way through the process, won the $228,000 that her advisor lost for her, she would have to pay $200,000 of the $228,000 to the arbitrator just to get that verdict. That is bananas, and it cannot stand. This is the problem that the SEC Office of Investor Advocates report discusses. It's the same problem that the Investor Choice Act, reintroduced yesterday, would solve. The fact is, there are lots of real people suffering extreme harm because of it. And they're not just numbers in a report from the SEC, they're people that are your neighbors. They're people that are school teachers. They're people that are nurses, and they're people that are just like you and your family members. A second example, a fraud victim also represented by PIABA members, Michael Phillips. He learned a difficult lesson after he went through a Finra arbitration proceeding that awarded him $4 million that he lost. But Michael to this day has yet to receive the award. The investment management firm Asia Pacific filed bankruptcy in bad faith to escape financial responsibility, something we see all too often. And it's effective, and it shouldn't be. The investment management firm just walks away and sets up shop under a new name. But that's why we're here. These are real people with real lives that are being impacted. It's clear that something needs to change, and it needs to change quickly. While we appreciate that the December Office of Investor Advocate report from the SEC agrees that this is a major problem, we have yet to see concrete actions to remedy the issue. Right now, it's just a report. Without rule reforms, it's business as usual for these fake fiduciaries. RIAs are still free to include anti-investor clauses in their contracts that waive investor rights, impose harsh rules, require travel to far-flung arbitration forums, and price American investors out of justice. While customers of broker-dealers don't actually face these obstacles. Why are we using two completely different sets of standards? Even as we know that harm that it has inflicted on real people like Rita and Michael. Over the next weeks and months, we're going to continue working with wronged investors, our partners, allies, the SEC, and members of Congress, trying to fix this problem for people like Michael and Rita. And we won't stop until we achieve some sort of fair process for wronged investors who fall victim to RIA misconduct. The SEC and Congress must act. It's a broken system, so let's fix it. Now I'll turn it over to my colleagues who are going to go into a little more in depth in terms of the specifics about what we expect the SEC and Congress to do. Christine, it's over to you.
Thank you, Joe. Hello, I'm happy to be here with my colleagues to talk about forced arbitration. I'm Christine Hines, Legislative Director at the National Association of Consumer Advocates, or NACA. NACA is a national nonprofit organization of attorneys and advocates actively engaged in promoting a fair and open marketplace that forcefully protects the rights of all consumers. Of those critical rights, it is particularly important for us all as consumers and investors to maintain our ability to enforce laws on our own when things go wrong. When we are cheated, defrauded, or otherwise lose out due to reckless, neglectful, or negligent conduct by bad actors in the marketplace, we have the right to go to court in order to be made whole. But corporate fine print contracts that we don't write and we can't negotiate trap us and prevent us from doing just that. Forced arbitration clauses in the terms and conditions of products and services are the problem we are addressing here that need an immediate fix. Evidence collected over decades overwhelmingly and repeatedly shows us that forced arbitration harms investors, consumers, and workers. It blocks their access to justice and shields wrongdoers from accountability. In this case, investors seeking to build wealth and financial stability increasingly have had no choice but to give up their right to be heard by a judge and jury in order to access investment advice. Instead, investors in disputes with advisors do not receive open public hearings. Advisors push them into a private, secret arbitration process where the advisors write the rules and investors are deprived of crucial due process protections. For example, even if an arbitrator gets it wrong, and no matter how badly they get it wrong, an investor has little opportunity for judicial review of that arbitrator's errors. Forced arbitration holds many advantages for industry players. They may settle investors' claims of wrongdoing, but settlements likely are far less than the harm and loss caused by the advisor's wrongful conduct. So we're very concerned about investors' lack of access to justice when they are harmed. We're also troubled by how forced arbitration fosters secrecy in the financial markets. In addition to investor arbitration being a private proceeding, the fine print traps facilitate more secrecy with confidentiality provisions, barring any discussion of the dispute, including of unlawful systemic practices that the public and lawmakers potentially should be made aware of. We agree with our colleagues that the use of forced arbitration directly conflicts with prohibitions on advisor self-dealing and self-serving misconduct that risks harm to investors. We are grateful for the SEC's recent steps to examine the issue in this sector. The Office of the Investor Advocate confirmed the secrecy and general lack of transparency surrounding the resolution of disputes between investors and registered investment advisors. The SEC also confirmed the proliferation of forced arbitration in advisor contracts. Congress and regulators have long known about the detrimental effects of forced arbitration. Congress, in its passage of the Dodd Frank Act, the 2010 financial reform law, recognized that greed and abuse facilitated by secrecy and suppression of consumers' and investors' rights were the main perpetrators of the 2007-2008 financial crisis. So it is past time to act. Indeed, the growth of new retail investors in recent years calls for immediate action to ensure their trust in the market and to prevent future crises. We would strongly support an SEC regulation or a law passed by Congress that would secure investors' right to choose how to pursue complaints against advisor misconduct, whether in court or arbitration, after the dispute arises. Thank you, and I'll pass it over to Brady.
Thank you, Christine, and thank you to Joe and PIABA for the opportunity to speak at this important event today. I'm Brady Williams. I'm legal counsel at Better Markets, and Better Markets agrees with all of the points that have already been shared here today. Clients of investment advisors are routinely being forced into private arbitration forums that are grossly unfair to investors. The recent SEC report to Congress on arbitration among investment advisors found that a strong majority, 61%, of investment advisors incorporate mandatory pre-dispute arbitration clauses into their investment advisory agreements, a finding the SEC characterized as conservative. Thus, investors are often left with little meaningful choice but to contract with an advisor who imposes arbitration at the outset of their relationship. These arbitration forums are fundamentally unfair to investors and are stacked in favor of the advisors. Investors should not be forced into arbitration at all, and the harm is compounded when the arbitration forum chosen by an advisor imposes extraordinarily burdensome terms and costs. Consider the list of unfair provisions often found in arbitration contracts between investors and advisors. First, filing fees and hearing fees can be potentially huge. The staggering costs associated with private arbitration forums typically forced upon investors operate as a shield for investment advisors and a barrier for investors. Consider the example shared in our letter and earlier today of the advisor client who faced a potential bill from the arbitration provider of up to $202,000 for an arbitration hearing on a claim involving principal losses of $228,000. A complete win would net her virtually nothing, while losing the case would double her losses. And there are other common terms clearly designed to discourage investors from even bringing their claims. Hedge clauses seek to narrow the types of misconduct for which the advisor can be held liable. Choice of law clauses mean that the body of law most favorable to the advisor will apply to the proceeding. And even the venues stipulated in advisor contracts are designed to burden investors by maximizing the time and expense of attending hearings. And as our letter makes clear, there is far too little information available about the claims lodged against advisors and whether those claims have been paid. These practices are indefensible, particularly when they come at the hands of investment advisors who are supposed to be always acting in the best interest of their client. Better Markets and others believe that the financial services industry should simply not be allowed to force their clients into arbitration. But at a minimum, The SEC should have more information about the use of these clauses in the world of investment advisors where the abuses appear to be most egregious. Thank you, and I'll pass it to my colleague, Martha Perez Petamonti.
Thanks, Brady. Good afternoon, everyone. My name is Martha Perez Petamonti, and I'm an Access to Justice and Consumer Rights Advocate at Public Citizen. Public Citizen is a nonprofit consumer advocacy organization that champions the public interest in the halls of power. We have 500,000 members and supporters throughout the country. I would like to thank PIABA first and foremost for inviting us this morning. My colleagues here today for all of the work and advocacy you do on this issue, and the press for being here and for elevating this important issue. And really, the issue we're talking about is choice. Specifically, the issue of investors having the ability to choose where, when, and how they want to seek legal redress for claims that arise against their RIAs, Registered Investment Advisors. As we have heard from my colleagues today, the use of arbitration clauses in investment advisor agreements affects investors from all backgrounds. Let's be clear here, this is not a rich people issue. It is an all-person issue. Really, it's an all-person problem. All people should be allowed to access the courts to seek redress for their legal claims. As we have heard, in December 2023, the SEC's Office of Investor Advocate took the extraordinary step of recommending that the SEC consider temporarily suspending the use of mandatory arbitration clauses in advisor agreements. We agree, and we would go a step further. We recommend that mandatory arbitration clauses in advisor agreements be banned permanently. To this end, I am proud to report that a cohort of organizations led by Public Citizen and Better Markets submitted a letter yesterday to the SEC Chair Gensler asking the Commission to issue a rulemaking pursuant to its authority under Section 921 of the Dodd Frank Wall Street Reform and Consumer Protection Act of 2010, mouthful, banning the use of forced arbitration clauses in broker-dealer and investment advisor agreements. The letter was signed by 17 organizations, including a trade union, consumer rights, and civil rights activists. The range of signatories highlights the wide breadth of support in favor of the SEC protecting investors from clauses that strip them from their ability to access the courts. To be clear, we do not stand against the concept of arbitration. We stand against forcing investors to agree to arbitration even before a dispute arises as a condition of using the services of a broker-dealer or investment advisor. We are proud to stand with our fellow advocates here today in highlighting this important issue. Thank you so much, and I pass it to my esteemed colleague, Micah Hotman.
Thanks so much, Martha. I'm Micah Hotman, Director of Investor Protection at the Consumer Federation of America, and thanks to all of my fellow panelists. I agree with everything they said. Advisors should not be able to use forced arbitration clauses to immunize themselves from accountability for their misconduct. If an advisor uses forced arbitration in ways that effectively deny a client's ability to pursue justice and recover for losses that they've suffered, the advisor is placing their own interest ahead of their clients in violation of their fiduciary duty. No reasonable investor would consent to the use of such clauses. I also want to add a few points to the discussion. First, as the SEC Investor Advocates report makes clear, in contrast to state registered advisors and broker-dealers, there is a lack of information about the extent to which registered investment advisors use forced arbitration clauses and how such clauses affect investors. The standard that guides federally registered advisors is disclosure obligations in this context. Whether the information is material leaves considerable discretion and flexibility for federally registered advisors to disclose information about the use of these clauses and how it affects clients' ability to pursue justice and recover losses for that they've suffered. Because we don't have a complete picture of the scope and extent of the problem, federally registered investment advisors should be required to disclose more detailed information about the use of forced arbitration clauses, which could help inform investors in selecting an advisor, as well as future regulatory action. Second, It's important to recognize meaningful differences between Finra arbitration for broker-dealers and investment advisor arbitration. I'll focus on 3 key differences. First, Finra exercises oversight over the broker-dealer customer arbitration process and has rules in place designed to ensure the fairness of the process for investors. In contrast, investment advisor arbitration is not overseen by either an SRO or the SEC, and the rules set by private organizations do not ensure the fairness of the process for investors. In addition, Finra rules prohibit firms from requiring customers to waive their ability to bring class actions. In other words, banding together when they've suffered the same harm. This ensures that investors hold firms that engage in widespread systematic misconduct accountable. In contrast, investment advisors are allowed to prohibit clients from pursuing class actions, which could impede clients from holding their advisor accountable if their advisor engages in systematic misconduct. Third, Finra rules provide an avenue for investors to bring small dollar claims against their broker-dealer. That avenue exists in part because firms subsidize the Finra dispute resolution process. However, there is no similar mechanism for clients of investment advisors, which is partly why it can be so cost prohibitive for many advisory clients to bring small claims against their advisor when they are harmed. Advisors who take seriously their obligation to act in clients' best interest should consider the feasibility of a special forum that allows advisory clients to bring small claims, especially because these clients are often the ones who need to make every dollar count and can least afford to suffer unrecoverable losses. The last point I'll make is that investment advisors are regulated by either the SEC or state securities regulators, depending on the amount of assets they have under management. Therefore, in order to have a truly comprehensive solution for all investors who use an investment advisor, we need both the SEC and state regulators to act in this space. Thanks so much.
All right, thank you, everyone. That takes us to the Q&A portion of today's event. I want to thank those who have been watching along, who've submitted your questions. And as a reminder for those watching along, you can send in additional questions to afrank@hastingsgroupmedia.com. Again, that's afrank@hastingsgroupmedia.com. We will take our first question. Our first question comes from Miriam Rosen at Advisor Hub. Miriam asks, can you address what, if any, steps the SEC has taken to address the IRA mandatory arbitration problem since its staff released the report this summer? And is a lack of action by the SEC the reason for this campaign?
Well, I think the SEC is probably the best folks to say what they've done after the report came out and over the summer. There was another report by the Office of Investor Advocate in December, and I don't know what they're doing. I hope they're doing something because this is an awful big problem. And yeah, that's why we're here. We're here because this is a problem that demands a solution, and we're not going to stop until one exists. So, we'll keep coming back here, serving sandwiches at the National Press Club or whatever we have to do and meeting with members of Congress until this thing gets right.
And Miriam has a follow-up. I think this is directed for you, Martha. What coalition members here today are mentioned in the letter that you referred to in your comments before?
I don't have the letter in front of me, so
Okay. Yeah.
but my recollection is NACA, Better Markets, and Public Citizen are all signatories to the letter, but I'd have to double check.
I think PIABA too.
Yeah, great. Do we have any additional questions in the room right now? Here, let me hand the microphone over.
I'm Mark Sheff with Investment News. I have an apples and oranges question, or maybe it's only apples and oranges in my own head. Would you be satisfied if the SEC said, okay, RIAs have to use FINRA's arbitration system? In other words, if all of these RIA cases that are going to private forums are instead adjudicated through FINRA, does that assuage your concerns? Or are you looking not only for RIA arbitration reform, but also Finra arbitration reform? In other words, forcing Finra to allow choice in forums.
So I'll take that to start, and then everybody can jump in. Yes, I think that it absolutely investors should have the freedom to bring their claim wherever, whether it's in court or in arbitration, and that's whether you're a Finra customer or you're an RIA customer. Which, by the way, no investor understands the difference whatsoever. But right now, what we have is a system where RIAs, who are fiduciaries by their very nature, and they market to that nonstop, actually have a worse dispute resolution system than Finra. And I've spent probably 20 years picking on Finra and their arbitration system, and I think there's a lot of problems with Finra arbitration. However, the RIA system is far, far worse. So if we could get as a start, as a first baby step, that we at least have the protections in Finra arbitration, that would be a step in the right direction. Would it get us all the way there? From my perspective, absolutely not, but it's better than the system we got right now.
Yeah, I will address that quickly. So I think that under the Finra process, the SEC may be able to collect more information because there's clearly not a lot of information for registered advisors, but there is there's no choice if they're forced into Finra arbitration, as you stated. Section 921 of Dodd Frank said that the SEC has authority over broker-dealers and the advisors to write a rule. And Congress also has introduced legislation, the Investor Choice Act, to address both as well, and we strongly support that. We think that individuals should be able to choose after the dispute arises. It shouldn't be one party's choice.
I told Rick Barry, the head of Finra arbitration, that Finra arbitration is better than RIA arbitration, but it's a little like being king of shit hill. You know, it's not quite where we want to be.
Thank you.
Yeah, you want some?
Yeah, sorry, let me bring the microphone.
The Dodd Frank Act has been on the books now since 2010. We've had Democratic SEC chairs. We've had Republican SEC chairs in the last going on 14 years now. No chair has touched that provision of Dodd Frank to address forced arbitration in the broker-dealer world. Now you're going to the Gensler SEC with your advocacy for reform of RIA arbitration. The Gensler SEC has an agenda of 50-some proposals already. RIA reform is not on there. So what hope do you have that the SEC will address this? I mean, it hasn't for 14 years, and now it's got a huge agenda. How do you break through?
Well, I think we have been breaking through. I mean, I think that's what's happened with this Office of the Investor Advocate report. They were asked by Congress to try and get their arms around this problem. One of the big issues is there hasn't been a lot of data. You know, what there is a lot of people like me who have 65-year-old men and women walk into their office and they've lost their life savings and they're devastated, and we are on the front lines of that. So we see that. What there hadn't been until very recently with this Office of Investor Advocate report is some real data on what the scope of the problem is. And once you understand the scope of the problem, then it really is incumbent upon the SEC to do something. So I do think we've got some momentum going on that.
I agree, and I would add that this issue is untenable, not just in this. In the Federal Registered Investment Advisor arena, but across the board, forced arbitration is getting a lot of attention, and it is a widely understood negative situation for consumers across the board. But in this situation, I agree, there is momentum, and we feel that 17 signatories to our letter is a wide breadth of support, and we are certainly encouraged by that. But we're also realistic, right? We understand that the SEC has a long list of to-dos, but we certainly are not going to let them forget that this is one of the important ones as well.
If I can add one point that I think was implicit in your question. In my view, I don't think the SEC necessarily has to engage in rulemaking to address this problem. I think that they could provide guidance and provide some fact patterns that they would view as inconsistent with an advisor's fiduciary duty. For example, if it's too cost prohibitive to bring small claims, if investors are required to travel an unreasonable distance, if the rules are procedurally or substantively unfair to investors, if there is secrecy that doesn't allow other investors to make an informed decision about who to select as an advisor, I think those factors should be deemed inconsistent with an advisor's fiduciary duty.
Okay, we do have an additional question. Question is, recently there's been a lot of activity around addressing forced arbitration in other areas like workplace and sexual harassment. Do you see this campaign as a facet of a larger sea change in the legal system? And furthermore, and there seems to be bipartisan support for action on forced arbitration in other areas. Are you seeing bipartisan interest when it comes to IRA forced arbitration as well?
Yeah, I don't think this is really a partisan issue. I mean, I agree with you. What's happened is there's been this private, secret form of justice that's developed in America where people are forced into it without really even knowing about it because it's in like 8-point font on page 36 of your investment contract or page 18 of your employment contract. And Congress, on a bipartisan basis, overwhelmingly decided to get rid of forced arbitration in the context of sexual harassment and sexual assault and things along those lines. When you have an assault on someone's life savings, when you have other issues that are forced into these private forums that are expensive and secret, the bad guys thrive in the dark. Bad people doing bad things don't like sunlight. And I don't think it is a partisan issue to say that all of these sorts of disputes should be out in the open so that if you're someone, and I don't care whether you're somebody who is a plant worker, somebody who is an electrician, somebody who is an insurance executive, somebody who's a neurosurgeon. I've represented all these kinds of people. They don't know, and they deserve to have their day out in the open, and they deserve to know whether their investment advisor or their broker has been in disputes before, because most people that are RIAs or brokers are good people, but some people are recidivists. And you should know that before you invest with them.
If I may add to that, I completely agreed. And I do want to point out that collecting data is extremely important. Granular data is what drives policy. However, collecting granular data, especially as it relates to minority groups or, in this case, small retail investors, it takes time. And sometimes that, we've seen that the small granular data is important, but we're also seeing the large scale impact of these forced arbitration agreements, whether it's large scale in terms of money, finances, affecting folks, or in terms of impact. And that's when we're talking about like larger effects for minority communities or whatever it is. And so given that these large scale impacts are so visible, I think that part of this letter and part of the advocacy here is that we need large-scale policy decisions now, and waiting for granular data just seems like it's unfair to the consumers that are being affected on a day-to-day basis.
It's not that just Republicans or just Democrats get ripped off by unscrupulous RIAs. It's everybody. They don't care. They don't want your money. They don't see red or blue. They see green.
Mark, do you have an additional question?
Yeah, that's great.
One
Nice
more.
to see you.
You said this is a bipartisan issue. Who introduced the Investor Choice Act and doesn't have any Republicans on it?
Somebody else answer that question.
Representative Foster and Senator Markley. There are no Republicans on it yet.
Just wait, though. We're working on it.
We do have one additional question. This question, I think, is aimed at Micah. Can you extrapolate a little more about the rule differences between broker-dealers and investment advisors, and specifically why they're so different?
Well, Finra controls the rules, and those rules are subject to SEC approval, and they are designed to ensure that Finra has a record of improving the process for investors. Are they as robust as they should be? No, but I think Finra does deserve credit for improving the transparency and accountability for broker-dealers to ensure that investors, are treated fairly.
And that's been something that's been improving over the course. I've been doing Finra arbitration since 1999. It has gotten better. And that is because there has been a lot of focus on Finra and their arbitration system. As we see people leaving the broker-dealer space and going into the RIA space, I think it's becoming more and more and more important that the RIAs at least catch up.
Well, it doesn't look like we have any additional questions at this time. All right, I just want to thank everyone for joining us, and for those especially who are watching along. If you'd like to be connected with any of the speakers that you've heard from today, you can contact Alex Frank at 703-276-3264, or again at afrank@hastingsgroupmedia.com, and I'll make sure to connect you. I want to thank all of our speakers as part of this Investor Advocacy Coalition. Again, from PIABA, the National Association of Consumer Advocates, Public Citizen, Better Markets, and the Consumer Federation of America. And that concludes today's news event. Thank you, everyone.